Mr. Freeman is once again uninformed and misinformed. First of all, he believes it is the role of the U.S. military to guarantee, protect, and or expand personal freedoms, specifically Mr. Freeman's. It is not the role of the U.S. military to do that. It is the role of the U.S. military to protect the U.S. from invasion and to enforce U.S. foreign policy. Next, Mr. Freeman is woefully uninformed and or misinformed that it is the role of the prosecutor to somehow protect Mr. Freeman's liberty. It is not. We have what is called an adversarial system. It is the role of the prosecutor to attempt to gain Mr. Freeman's conviction. It is the role of Mr. Freeman's defense attorney to attempt to stop the prosecutor from gaining the conviction. It's the role of the judge to make sure that both sides play fair and to make determinations of law. It's the role of the jury to determine the facts, who to believe, who to not believe, and what weight to give any specific piece of evidence. Next, our fine friend believes that somehow bail is for, or bond, is for just securing his showing up at his next hearing and or trial. It is not. This is 18 U.S.C. 3142. This is the federal U.S. code regarding bail or bond. You may notice that if you are released on personal recognizance or unsecured appearance bond, it is subject to the condition that a person not commit a federal, state, or local crime during the period of release. Fancy that. What if you're released on conditions? Well, one of those conditions is subject to the condition that the person not commit a federal, state, or local crime during the period of release. Go ahead and fancy that. Part of the purpose of bond is to keep people from committing crimes. If you continue to commit crimes, you're going to have your bond revoked or increased. It is as simple as that. Next, Mr. Freeman seems to believe that he needs to be viewed as innocent until proven guilty by all portions of the legal system. Once again, he is uninformed and misinformed. In the eyes of the jury, he is considered innocent until proven guilty. In the eyes of the police, he is not. In the eyes of the prosecutor, he is not. In the eyes of the judge, he is not. That is a stupid thing to say. The judge has to consider that you may, in fact, be guilty, or else the judge would not allow the prosecution to continue. The prosecution has to believe that you may be guilty, or else it would be an ethics violation. The prosecutor would be culpable if he allowed the prosecution to continue. The police have to believe that you may have, in fact, committed a crime in order to arrest you. Don't be ridiculous, Mr. Freeman. They have to consider that you are very possibly guilty. So you being arrested twice in Leon Valley after being arrested in the state of Arizona should, would, and could lead them to believe that you may have, in fact, committed another crime while you were out on bond, thus violating the terms of your bond, thus making it likely that it will either be increased or revoked. Last but certainly not least, Mr. Freeman, you were not found guilty of that first arrest, or found innocent, I should say, of that first arrest in Leon Valley. The magistrate found that the police lacked probable cause. The magistrate did not find that you were not guilty. There is a difference. It is enormous. You should figure it out, especially if you're going to be playing in the legal system like you are wont to do. You must understand that most people don't get arrested nearly as often as you do. Most people, in fact, don't get arrested. That being said, the finding of a magistrate that the police lacked probable cause does nothing. Jeopardy has not attached. The only thing that means is that you were not arrested. Yes, it was an unlawful arrest, but that and $5 may buy you a Starbucks, depending on whether or not you have a coupon. Anyway, that is it for today from my balls hot living room with my door and my windows wide open. Pity me. It's going to be several days before they get a compressor. Thanks for watching. Have a great day.